we're talking to former Supreme Court Associate Justice, Attorney Adolfo Azcuna. Good afternoon, sir. Thanks for joining us.
Good afternoon, sir.
Hi, Justice.
There's been some confusion apparently over when is an impeachment complaint deemed initiated, and therefore when the one-year bar takes effect, especially after last year's decision by the Supreme Court, of course, by Justice Leonen, printed by Justice Leonen. We understand, of course, yung Francisco versus House says that initiation begins with the referral to the Justice Committee. Pero yung the Leonen decision po, I read it again last night, at least parts of it. There were some things that struck me. There was a part there in the decision that says the one-year bar is reckoned from the time an impeachment complaint is dismissed or no longer viable. So ano po talaga ang what is your interpretation, sir? Is it when it is referred to the Justice Committee, that's when we start counting 1 year, or is it when a complaint is dismissed or all the complaints are dismissed?
So palagay ko yung statement doon ng decision penned by Justice Leonen in the Sara Duterte case refers to the facts of the case. And in that case, what happened was the first 3 complaints were archived.
Yes, sir.
And Justice Leonen said that the archiving of the 3 earlier complaints resulted in their being effectively dismissed.
Yes, sir.
And therefore, he said, since you cannot dismiss something that you did not start, they are also deemed initiated. So, since the cases that were archived and dismissed must necessarily have been initiated, he said that their dismissal connotes a triggering of the period of 1 year, because it is in effect initiated the complaint. It does not say exactly when it was initiated, but it says it is inferred by the dismissal that it had been initiated.
Opo. So, sir, let me try to put it in layman's language po for all our viewers. Tell me if I'm getting this right. What you're saying po is, according to Justice Leonen's ponente, hindi siya madidismiss kung hindi siya na-initiate. Therefore, na-initiate na siya.
Yes. That is why the statement refers to dismissal, because there was no clear time element of the initiation. But Justice Leonen said necessarily when you dismiss something, that means you had initiated it. And therefore it said that it triggered the archiving. It's the archiving process, which involved both initiation and dismissal. In effect, triggered the 1 year period.
And do you agree with that interpretation, Justice Azcuna? Because there have been cases before where complaints were dismissed without necessarily being initiated, right? For instance, if the complaints lacked merit.
Yes, the question there is whether or not it has abrogated the former definition of initiation as promulgated in the Francisco case. I believe that the Francisco decision is still good, especially when the complaint is one that is referred to the committee under the first or second mode, where the complaint is filed by a citizen and endorsed by a member of Congress, or a verified complaint is filed by a member of Congress, and then it's referred to the Committee on Justice. That definition of referral to the committee as being an initiation of the impeachment proceedings is still good. But in addition, if Congress does not refer it to the committee, but merely archives it, that too is an initiation.
Okay.
So kahit hindi ma-refer sa committee, let's say it was never endorsed or was not a verified complaint by a member of the House, considered initiated na din po yun, Justice, in your view?
Yes, in my view, in this case, what happened last is that it was referred to the committee, a complaint filed by a citizen and endorsed by a member of the House, referred to the committee. That is an initiation under the Francisco ruling, even before it's dismissed, because dismissal is just another kind of initiation.
Justice,
sige.
we've had many impeachment cases in the past, ano? Pero ngayon lang yata magkakasabay yung ini-impeach yung presidente at vice-presidente. Paano kaya yan? Meron ba yung prioritization kung sakasakala? Because they're almost simultaneously being tackled by the House, ano? Paano kaya yung magiging mechanism niyan? Yun muna,
okay.
my first question. My second question, ang mangyari pag pareho silang na-impeach?
Kung halimbawa sabay magkaroon ng impeachment complaint against the president and against the vice president, paano nila i-prioritize unahin nila? It's up to them. The Constitution provides that Congress may adopt rules to implement the provisions on impeachment. So they may have rules regarding that particular situation as to how they will treat a simultaneous kind of impeachment complaints against both the president and the vice president. That would be up to Congress to decide on the matter.
Paano kung pareho silang, it will go to trial, no? Let's presume that it will both go to trial. At paano kung matanggal yung president at vice president? Ano mangyayari sa gobyerno?
Depende kung sino unang ma-convicted.
Yeah.
If you convict the president first, then the vice president becomes president, and maybe the case against the vice president will become moot because he or she no longer occupies the office of vice president. On the other hand, if the vice president is the one earlier convicted, then the office of the vice president would be vacant. And if the president is subsequently convicted also, when the situation will be one where both the office of president, the office of vice president are vacant. And there's a provision in the Constitution as to the succession. If that happens, there's a temporary provision that the Senate president will act as president until the elections is held for president and vice president.
Justice, that
regular
was...
election yon. Regular election yun, ano? Not a snap election. Kung sakasakali.
Depends on whether or not the regular election is already within, I think, 18 months. In which case, then we just wait for that. Otherwise, they can hold special elections.
Okay.
Justice, something you said I found very interesting. If the president, if the president got convicted first, and the vice president steps up and becomes president,
Magiging moot.
so you mean hindi na matutuloy ang impeachment trial ni VP kung sakaling mabot doon, kung sakaling mabot doon, hindi na matutuloy yung impeachment trial ni VP because she is no longer the VP, and therefore in effect basura na yung complaint.
Magiging moot.
That's one interpretation. That is, if you consider that removal from office or a vacation of the office or resignation from the office renders the case of impeachment academic. But there is another element that is involved in impeachment, which is disqualification. So it can be argued that even if the vice president has become president, the case against him or her can continue with respect to the disqualification aspect.
Okay.
And if he or she is disqualified, then the accession to the presidency would be invalid because disqualification refers to any and all offices under the republic.
So that's still a gray area.
Yes, so it depends really on your view on whether or not disqualification can continue even after the respondent vacates the office.
Pero until the vice president, halimbawa na convict ousted si presidente, and the vice president has not yet been ousted through impeachment, automatic yung succession, di ba? She will become the president. Pag natanggal si presidente by impeachment, at yung vice president is still sitting as vice president, automatic magsasucceed siya as president.
Yes, depends on the sequence. If the
Yes.
president is convicted and removed first, while the vice president is
Yes.
still vice president, then the vice president succeeds as president. And what happens to the impeachment case against the vice president who has succeeded as president is something, an open question. It may or may not continue. On the other hand, if the vice president is the one removed first, then it's just simple case of a vacancy in the office of the vice president. There is a provision on how that is filled.
Yes.
Yes.
And if that is the case, the president, di ba, can nominate a new vice
Kapalit.
president to be confirmed by the Senate, if I remember correctly.
Yes.
That's what happened in Tito Ginggona.
Yes, that is the provision. There is I think the confirmation is by Congress.
And in which case, if the president then, I'm sorry, we're
If
digging
the
deeper
vice-
into hypotheticals. But kung sakali pong natuloy ang trial ng Pangulo at siya'y natanggal, yung na-appoint at na-nominate niya at kinonfirm ng Kongreso na Vice Presidente ang magiging
Automatic.
Pangulo.
Yes, if the person who succeeds as vice president, let's say one of the senators assumes the vice presidency, and then the president is impeached and removed, then that person who succeeded as vice president becomes president.
Ang daming permutations.
Oo nga eh. Technically, the one-year bar for impeachment for President Marcos has been triggered because the first two complaints have been sent to the Justice Committee by the lower house. So yun, klaro yun, na-initiate na. But in terms of, so earlier you said it really depends on them, on Congress, which of the two impeachment complaints they'll tackle. But is there, logically, is there a hierarchy in terms of the charges? Kasi when you look at the charges against
Magkaiba.
the two, magkaiba, although, I mean, there's a lot of similarities. For example, betrayal of public trust, culpable violation of the Constitution, graft and corruption. Pero yung particulars ay magkaiba. So in the case of Vice President Sara Duterte, for instance, it seems mas marami siyang examples to argue the case. In the case like that, let's say both, and next week is already February 6th, which is when her one-year ban expires. If the two impeachment complaints reach Congress at around the same time, what do you think, in your view, should they prioritize?
On the assumption that the two complaints are referred to a committee, as in this case, it is up to the committee to whether or not to join the two complaints into one or to treat them separately. What is important is the grounds, the counts, how many counts there are. Each ground will consist of a count, and the report of the committee to the House will be the one that will be followed. They might report back two complaints or just single unified complaint.
So each complaint each charge is a ground. Do you mean to say that the more grounds, the more urgent they should treat it?
Yes, every ground is urgent, but it's up to the.
It's really up to the Congress, okay.
It's up to Congress. It's up to the committee really to define these grounds when it makes its report within 60 session days from the referral.
Justice, balikan ko lang po yung when we begin to toll the 1-year bar, at least based on the Supreme Court decision last year. Well, klaro naman po kasi yung sa Francisco case kasi di ba, that's just basically referral to the Justice Committee. That's initiation already. Do I get it right na kasi there was supposed to be a third impeachment complaint na hindi lang natuloy yung impeachment complaint ni Mike Defensor, Ferdinand Topacio, Chavit Singson. Hindi lang siya natuloy. Yung natuloy
Kasi
lang
walang nag-endorse.
sa SecGen, yung dalawa, yung kay Andres De Jesus tsaka yung sa
Kabayan.
Kabayan Block, at yun ang ni-endorse dun sa ni-refer sa Committee on Justice. So, okay na po yun. I'm wondering lang, kung tama interpretation ko sa ganito kung sakaling tinanggap, kasi hindi tinanggap yung third complaint kung sakaling tinanggap ng SecGen yung third complaint from the Duterte group at hindi siya inakyat sa order of business at nirefer sa committee, that in effect would have been a dismissal of one of the complaints and that would have triggered the 1-year bar. Would that be correct?
It's not really a dismissal, more like a non-acceptance of the complaint simply because it's already barred.
Non-admittance of the third complaint, sir, Justice?
Yes, it depends. In my view, if they were all referred in the same day, let's say, kahapon, kailan ba yung refer?
The other night.
Yesterday. It does not have to be referred at the same time as long as it's within the same day. That is considered a single referral. Because what is prohibited, what the Constitution says is no impeachment proceedings shall be initiated against the same official more than once within a period of 1 year. The Constitution doesn't say not more than one complaint. It says not more than once initiation. So if you initiate 3 complaints in a single day, that's only once, because the smallest unit of a year is a day. You cannot divide a day anymore into hours as far as the time in the law is concerned. The day, according to the law, is a year is 365 days.
And it's
So the
days,
smallest unit
Okay.
of a year is a day. So if you refer 10 complaints, different hours in a single day, that is only one
One
initiation.
referral.
One initiation of once a year.
Okay.
Oo.
Pero Justice,
Okay.
if theoretically, if there was an 11th complaint that was not acted upon by the Secretary General and not brought up to the order of business and then referred to the Justice Committee, if there was one that was not acted upon, that would
Not
become
acted
amount to
upon
dismissal.
after the first 2 had been referred to the committee.
Opo.
Yes, so that one that was not acted upon is not initiated because it was neither archived nor was it sent to the committee, and those are the 2 ways of initiating. So it was not accepted. It was not accepted by the committee, by the Congress. Probably because of the earlier referral of the 2 already.
Justice, I'll digress a bit, Kasi the Vice President is facing another legal problem, yung criminal complaint against her. Plunder and malversation, I think, and graft before the Ombudsman. Ang tanong ko lang if she is convicted, pwede ba siya, she can be removed only by impeachment, no, the Vice President. But if she is convicted with finality, although medyo malabo yun, within 3 years, she can be permanently barred from holding public office with finality.
Convicted where? By whom?
Sa Sandigan Bayan, and then it will go up, let's say, biglang bumilis at umakyat hanggang sa Supreme Court, final decision ng Supreme Court. can she be permanently barred from holding public office?
Bali, kung gumulong po yung criminal case,
Na vice president pa siya. Nagkaroon ng final
I
conviction.
see. That is questionable because the rule is that an impeachable official must first be impeached before a criminal case can be filed against him or her.
Ah,
You cannot convict the person in a criminal case without
they're in
first
office.
filing an impeachment case. So that will not be a valid conviction. Ang impeachable official kailangan po impeach muna bago filean ng criminal case.
but sir,
convicted by impeachment first, bago
Before the
file ng
criminal
criminal case.
Yes, but what they can do is they can investigate, but they cannot file the criminal case until they first file an impeachment complaint. And if they are not able to file an impeachment complaint because of the 1-year ban, then they cannot file a criminal case against the person. They have to wait for that 1-year ban to expire, file an impeachment case, have the impeachment case terminated, and if
Yes.
he or she is convicted, it says that is without prejudice to a criminal case. Then you can
What
file
if she is
the criminal-
cleared in the impeachment? Can she still be pursued sa criminal case?
If the case results in dismissal of the
Quit-
impeachment case, then you're back to square one, where you have to file an impeachment case before you can file a criminal case.
Ah, okay.
Yeah.
Justice, pasensya po non-lawyer here, so I just want to make sure that I'm getting this right. So, if you're an impeachable official po, you cannot be charged tama, in a criminal case unless there is already a pending impeachment case. Tama ho ba?
You cannot be charged at all without first
Unless you
going
are
through the process
convicted.
of impeachment.
Unless you are charged with an
Convicted.
impeachment case or unless you are convicted of an impeachment case.
Charged.
Yeah. In other words, an impeachment official is immune from a criminal case
Opo.
because he or she must first be impeached.
Must impeach-
There must
yeah,
first be a
opo.
complaint for impeachment filed against her before a criminal case can be filed.
Yes, sir. That's what I mean po eh. Must that impeachable official first be removed through impeachment before you can file the charges? Or can you file the criminal charges while there is a pending impeachment case?
Impeachment.
You cannot file while it's pending. You have to first wait for a decision in
Okay,
the
convicted muna.
impeachment case. And if the impeachment case results in a conviction, then you can
That's the
file
only
a
time.
criminal case.
So,
Okay,
so immune
that's clear.
sila whilst they're still in
Yes.
office, kahit na gumugulong na yung impeachment case.
But can you be prosecuted? Kahit
Pardon?
wala pa. Can you be can the impeachable official be prosecuted? Meaning, will undergo investigation by the ombudsman before being transmitted to the court. Pwede ba na meron pang immunity from prosecution? Hindi ba presidente lang yon? Can the vice president be investigated for a criminal offense while ongoing yung impeachment proceedings? Investigation lang.
That's true. That is the former rule that only the president's immune from criminal prosecution.
Yes.
But there is a Supreme Court decision that says that impeachable officials cannot be prosecuted for crimes that are grounds for impeachment without first going through impeachment. That's why while they are not immune, there is a sequence of remedies. You must first file an impeachment case, pursue the case through impeachment before you can resort to a criminal case in cases of impeachable officials.
Pero impeachable offense ba yung malversation through falsification of public documents?
Yes,
Kasi yun yung final
yeah.
That
Is it an impeachable offense?
Yes, that's
Yeah.
a high crime.
Justice, sorry, let me just interrupt and introduce our political pundit. Of course, he doesn't need introduction, but he just joined us, so I have to acknowledge him, resident pundit Ronald Llamas.
Good afternoon, Justice. Long time no see.
Hi, good afternoon, Ronald.
Okay, I wanted to come back as well to the procedural aspects. I want, Justice, if you could weigh in on, because every time we talk to members of Congress right now, they tell us, we're going to wait on the Supreme Court decision on the motion for reconsideration. Remember, wala pa yung decision, so they said whatever the Supreme Court decides, they will abide by it. Kasi the Supreme Court made it harder to impeach officials, right? So nag-file sila ng MR, now we're waiting on that decision. On the other hand, I also know from previous interviews, you've said that Congress actually has continuing power to adopt rules, to modify rules as needed. So which one takes precedence here, right? Does that also mean they don't necessarily have to wait for the MR decision? They can just set their own rules for impeachment?
The first case was archived by the Senate, no? But the decision of the Supreme Court remains because it was immediately executory, although it is still subject to an MR. So I believe that whether or not that case is still alive, a second or a new impeachment complaint may be filed against the Vice President on February 6th and thereafter. In other words, if the one-year ban lapses, then a new impeachment complaint may be filed, even if there is still a pending one that was filed earlier. There is no prohibition against several pending impeachment complaints as long as they are not filed within 1 year together.
Pero sir, what rules will apply in...
Which one should they follow?
Kung hindi pa na-resolve itong MR...
Can they just set their own rules?
Oho.
Kasi I think the Constitution allows...
Yes. They have the choice. If there's an MR, if the MR is not resolved, then they cannot revive that first case because the Supreme Court invalidated it. So and that invalidation is effective until reversed by the Supreme Court. So they will have to consider the new case filed February 6th or thereafter.
Under the new rules until ma-overturn.
Anong rules yung mag-govern dito sa next impeachment,
Yun na nga
Justice? Is it the Article 11 ng Constitution or yung mga modifications na ginawa
Supreme
ni
Court.
Marvick Leonen? Na nagbigay siya ng mga 6 or 7 new rules for impeachment.
The rules on impeachment will have to accommodate the decision of the Supreme Court in the Sara Duterte case. But those modifications mostly refer to the third mode of impeachment complaint. That is when the impeachment complaint is filed by the members of the House, 1/3 of the members of the House signing the verified complaint for impeachment itself, then it constitutes the articles under that. So paragraph 4, according to the Supreme Court, in that case there are certain rules must be applied for purposes of due process. Those rules would apply if they follow this third mode now. But if they follow the first or second mode, that is referral to the committee, then those additional requirements will not apply.
For example, Justice, the requirement, the new requirement that
Accused.
that there should be sufficient evidence to prove the case dun pa lang sa impeachment process in the lower chamber.
Parang may preliminary investigation.
How does
di ba?
one define sufficient evidence to prove? Kasi parang wala namang ganun dati in the previous impeachment cases.
Yes, I believe that that has to be interpreted in connection with the facts of that case. And the facts of that case referred to third mode, where the members of the House allegedly had no time to really examine the evidence. It was rushed within one day. So these pronouncements will not apply to a situation where a complaint is referred to a committee, and the committee has 60
60
session
days.
days to deliberate and examine the evidence. There should be no violation if they follow that procedure.
Okay.
There is sufficient due process there in that committee procedure.
So it does not necessarily follow that the House will have to summon the Vice President before transmitting the impeachment, articles of impeachment to the Senate. Kasi yun ang sinasabi na iba eh.
The committee process usually summons the respondent.
Yep.
Yes. What happened in the case of Sara Duterte was that he was not summoned because it was not referred to the committee. It was
It was a
under the
shortcut.
third mode, where the members, 1/3 of the members, signed the verified complaint, and it transmitted it to the Senate without
Justice?
hearing, because there's no hearing under the third mode.
Justice, how about yung isang rule na dinagdag ni Justice Marvic Leonen, no? Dun sa third mode, no? Halimbawa, each and every congressman has to prove na nabasa niya at naunawaan niya yung articles of impeachment filed. So, how do you do that? Kailangan ba ng cognitive exams ng mga congressmen? Kailangan ba nila ng oral exams to show na nabasa
Signature
at
lang
naunawaan
siguro.
nila?
Oo, signature lang naman.
siguro.
And Congress will have to accommodate it somehow. And I believe that these additional requirements by the Supreme Court may be modified by Congress under its continuing power to adopt rules to implement the impeachment. So these are not unchangeable requirements. These are part of the rules on impeachment, which Congress can change, in my view. So if they can accommodate the spirit, but they do not have to follow it literally. Yes.
Pero the power of impeachment lies in the House eh. Di ba? So they can significantly modify actually the Supreme Court ruling when it comes to impeachment.
Sabi nila, they are going to modify the rules to accommodate
Yes.
the Supreme Court ruling. I don't know if they have done that, but usually they revise the rules prior to an impeachment case.
Yes.
Yes.
Pero Justice, in this particular case, na-initiate na yung impeachment case against President Marcos eh. So kung may nasimulan ng impeachment case, can they still modify the rules midstream, or should they have done it before?
Oh, yes, yes. The rules can be modified anytime. Yes, that is a continuing power. But the idea is in order to implement effectively the provisions of the Constitution.
Okay.
Uy, ikaw, Tito Ronald, baka may pahabol ka.
Okay na ako. Satisfied na ako sa mga paliwanag ni Justice Azcuna. Mas learned dyan eh. Tayo, kwan lang tayo.
Ang mga unlearned tayo.
Wait, maybe a last thing on the procedure, Justice. I wonder if you could weigh in on, because di ba may third impeachment complaint against President Marcos supposedly, but they filed it on a day when the House Secretary General was away.
Was abroad.
So she was not around officially to receive it. And we were just wondering why, why there's no protocol in place for to receive official complaints when one
During
person is away
absences.
during absences. And si Congresswoman Luistro told us that, well, it really depends on the office of the SecGen, that he or she can determine how it's received. I mean, does the Constitution say anything around that, yung protocol of for receiving formally a complaint?
Because the SecGen is just an employee of Congress.
That's just one person, right? Siguro,
She's not even elected.
that's true.
The matter is really falls within that time frame between the filing of the complaint with the House and the referral to the committee. It is supposed to be calendared within 10 session days. But if the Secretary General is unable to put it on the calendar for one reason or another, and then naunahan ito by two other complaints that were calendared and referred to the committee, barred na itong pangatlo. So, hindi na pwedeng i-calendar and refer to the committee. So, I believe that in such a case, this third complaint could no longer be considered. It will be barred by the first two that's already initialized unless it was done on the same day. Nag-lapse na yata yung day na yun eh. So, hindi na pwede itong third complaint.
Ito yung complaint nila Topacio.
Topacio and ano.
Correct.
Pero
Pero
magwawala si Learned Topacio, no? At saka si Jing Paras, no? Medyo magagalit 'yon. No, learned pa naman yung mga
Pwede-
'yon. No?
Pwede ba pagpahabol ibang topic?
go ahead, Ami.
You were a member of the Constitutional Commission, Justice eh. Ngayon, maraming 20 bills on the anti-dynasty provision to implement that constitutional provision. Meron ka bang minimum expectations kung sakasakali? Kasi it's taken more than 3 decades
4 decades.
para lumabas yan. Do you have any minimum expectations kung sakasakali man na may lumusot na anti-dynasty law?
Hopeful si Ami.
Itong dynasty, I have read all the 20 pending bills.
Yes.
There are really two kinds. No, one is the comprehensive, and the other is the moderate. Comprehensive would cover 4 degrees and all kinds of offices and prohibit both
Yes.
yung sabay-sabay at saka yung sunod-sunod. On the other hand, the moderate would limit it to 2 degrees and exempt national offices and apply only to local and barangay elections because the reasoning is that when the voting population, the voters are nationwide, the effect of dynasty power is diluted. So in the case of senators, for instance, it is believed that we can exempt it from the dynasty because the power of a dynasty is not so concentrated when it's spread nationwide, except for party lists. No, party lists they apply because it is the way it functions like it's regional also. So ganun ang tingin ko, there are two kinds, the comprehensive and the moderate. And I would go for the moderate because it's more doable, easier to prove, and easier for COMELEC to implement, and easier for Congress to pass. While the comprehensive might be too painful to realistically expect Congress to pass. So let's go for what is doable muna. And perhaps 2 degrees, which by the way, the Bangsa Moro adopted 2 degrees.
Yeah, 2 degrees.
Maybe doable.
Pero Justice, yung mga discussions nyo nung ginagawa yung 87 Constitution, including yung discussions over the anti-dynasty provision of the Constitution, di ba pwedeng gamitin yon to justify any implementing law about sa dynasty para consistent with the spirit of the 87 Constitution?
Pwede namang i-refer yun for purposes of determining the spirit of the prohibition.
Yeah.
However, we must remember that what we did was to leave the definition of political dynasty to the law. And that means, in this case, to Congress. We don't want to define it ourselves. And so the actual permutation of the rule will really depend on Congress.
Yeah.
The spirit, however, is to provide equal opportunity in public service that is mandated and guaranteed by the state. The state shall guarantee equal access to public service and prohibit political dynasty as may be defined by law. So there are two important things to remember. It is a guarantee by the state of equal access to public service. And secondly, that it is prohibited. There's no need for a law to prohibit it. It's already prohibited by the Constitution.
Yeah, correct.
Political dynasty
Yeah.
shall be prohibited as may be defined by law. What needs to be defined, what is needed by a law for is the definition of political dynasty.
Yeah.
But it is already prohibited by the state.
Yeah. Just very quickly, Justice, is that something that the framers of the Constitution regret, not giving a definition to political dynasties in the Constitution? Looking back in hindsight, is that something you would have changed?
No, I want it to remain as something that should be defined by law because it should adapt to changing times. The power and the manifestation of power of a dynasty may change over time. And so you have to adjust the definition of political dynasty and the prohibition to the situation. A good book to read, by the way, regarding the origin of our political dynasties and its nature and the way its power accumulates is one by entitled by Castañeda, entitled Foundations of a Modern State. And she says that the origin of our dynasty lies in the Spanish time when we had this kind of system, patronage. So malalim ang pinanggalingan ng ating sitwasyon ng political dynasty natin. The roots are way back in our history. So I prefer that the solution be through legislation because legislation is flexible. And it will not be frozen, and definition will not be frozen in the Constitution.
Fair enough.
Sometimes too flexible.
Well, no, I'm just dreaming of a constitution that defines up to the fourth degree. But then again, I'm sure people will find a loophole. But we will leave that there. Thank you so much
Thank you, sir.
for
Thank you,
explaining all of
Justice.
that to
Ingat
us.
parate.
Former Supreme Court
Thank you,
Associate
Justice.
Thank you,
Adolfo
thank you.
Azcuna.
Sana maisulat nyo yung idea nyo tungkol dito sa anti-dynasty, yung inyong version.
Thank you.
Thank you, sir.